Good afternoon. We have privilege in welcoming you to the first webinar of ICSI IPA. ICSI IPA is a Section 8 company and is a wholly owned subsidiary of ICSI and registered with Insolvency and Bankruptcy Board of India as an insolvency professional agency. Ms. Alka Kapoor, Joint Secretary with ICSI, is Chief Executive Officer of ICSI IPA. She has been with the institute for more than 25 years. We have our President, Ms. Mamta Binani, with us. And we have two eminent speakers, Mr. Sumant Badra and Mr. Alok Dheer, with us. And Mr. Sumant Badra is the chairman of Kesar Das B and Associates. As a senior international consultant to the IMF, World Bank Group, OECD and other developmental institutions, he has worked extensively on policy matters in Africa, Eastern Europe, Middle East and South Asia. Mr. Badra has been rated as #1 insolvency lawyer in India by Legal 500. His contributions to reform in Indian insolvency system are well recognized. He is a frequent speaker at various international and domestic conferences. Mr. Dheer is the founder and managing partner of Dheer and Dheer Associates, a full-service law firm in India. He is a veteran legal professional and a qualified chartered accountant with over 3 decades of expertise in corporate and financial restructuring, insolvency laws, M&A, takeovers, banking law and real estate. Mr. Dheer has been a member of NCLT Rules Formulating Committee and National Committee on Dispute Resolution. He is also on IICA's panel of experts for matters relating to corporate rescue and asset reconstruction, and he is also a member of FICCI's core group on insolvency laws. Now, Ms. Alka Kapoor will speak few words about IPA and IBC. Thank you.
Good evening. Dear professional colleagues, the whole new insolvency law is in place. With the Insolvency and Bankruptcy Code 2016, the rules and regulations made thereunder, as well as the notifications issued in respect thereof being in place. And of course, the new law, as we all know, is creating a lot of excitement as well as anxiety in the minds of professionals. It throws open both opportunities as well as challenges. A lot of opportunities have opened up for professionals in the area of corporate insolvency resolution process, corporate liquidation process, individual insolvency resolution process, individual bankruptcy process, and the liquidation of a corporate debtor firm. An analysis of the companies under liquidation as on 31st October 2015, furnished by the Department of Financial Services, indicates that there were a total of about 5,141 winding up cases pending, out of which 1,479 were pending winding up cases for more than 20 years. It is also reported that about 1 lakh cases are pending before the DRT. Further, the CLB receives almost 4,000 cases every year, which will now be transferred to NCLT. The causes leading to tendency may be, including tendency may be the tactics employed by company promoters to delay the reorganization or the attempts to sell off assets, changes in the management or litigation that goes on endlessly. The new insolvency ecosystem is a new generation law which proposes to provide breathing space to the stressed banking system and their dealing with the errant borrowers. It is reported that the stressed assets account for more than 12.3% of the total bank loans. Effective implementation of the Insolvency and Bankruptcy Code 2016 can potentially release about 25,000 crore capital currently locked up in the non-performing assets over the next 4 to 5 years. The released capital can be then employed for other productive lending, which in turn would help in credit expansion. Further, the code will help in India's banking sector catch up with or even exceed the recovery rates of 32% and the average time taken of 2.8 years in the other emerging markets. With the ongoing structural reforms, the code is expected to improve India's ease of doing business and the global competitiveness ranking significantly. Dear colleagues, as you all know, the code introduces new concepts of information utilities, insolvency professionals and the insolvency professional agencies, which of course will be deliberated in detail by the eminent faculty we have here today. The National Company Law Tribunal has started receiving applications under the code. It is reported that ICICI Bank and Edelweiss ARC have already filed applications with the NCLT for initiating corporate insolvency resolution process. In fact, yesterday, the application of ICICI Bank was discussed at the Mumbai bench of NCLT and the order regarding the application is likely to be out today anytime. So, dear professionals, as the law is unfolding itself and the applications are being filed with the NCLT, several issues are likely to come up to the fore, which would at times need clarity in law, structural evolution of process including information utilities, and at times a change in the code and regulations. There are major challenges too. The 180 days time-bound process for CIRP would be one such challenge. And the second and the most important is the capacity building of insolvency professionals. Lot of responsibility as well as trust and confidence is placed on the insolvency professionals under the code, and they will virtually become managers or managing directors in companies and so need to justify their role. Therefore, there is a dire need to educate and train them on the new law. Friends, to fulfill its role, to enroll, regulate, monitor and develop its members as insolvency professionals, the ICSI has established a regulator named the ICSI Insolvency Professional Agency, popularly known as ICSI IPA. This is a non-profit company as mentioned by Lakshmi, and the governing board of ICSI IPA consists of 7 directors comprising of 7 independent directors. The ICSI IPA till now has registered a good number of insolvency professionals under the limited period registration and is also in the process of registering the professionals who are coming with their applications consequent to the clearing of the examination. To update and develop its members, the ICSI IPA proposes to bring out several publications. It has released its first publication which broadly covers the code, the rules and regulations, notifications, etc. And this is the publication which is also available for sale to the members. We will be sending this publication on a complimentary basis to all the IPs registered with the ICSI IPA. We also plan to bring out a manual on the insolvency code and regulations covering in detail all the aspects, all the practical aspects and the procedural aspects thereto. The ICSI IPA also proposes to conduct training workshops for its members across India. We are at the final stages of putting up a website in place which would be ready hopefully by the end of this week. So friends, we have a new law in place under a new regulator, the IBBI, the new agencies to register and monitor the professionals, and a new breed of professionals. In fact, the only ones to be called professionals, the insolvency professionals, you all, who will be working towards making the new insolvency law successful and placing India in the higher echelons of the international arena. Thank you. I now request our President, Mrs. Mamta Binani, to kindly share her thoughts on the subject.
Namaste ICCINs, and of course all the professional fraternity and the other stakeholders of our esteemed country who is viewing this webinar on insolvency and bankruptcy code 2016. Friends, at the outset I must place on record, and this is, I think, an equivocal statement by all who are following this law very closely, and that is the speed at which the government of India has taken this code, the upheaval task that they have done to bring this into the forefront and see the light of the day has been very, very commendable. As ICSI from the Central Council and being in quite a number of the working groups of the government of India, we have been a witness to the fact that the way government has worked for it, I think at times we said to ourselves that the speed speed is just a lightning speed. And at times we saw that the person from the government, and I closely worked with Mr. Amardeep Bhatia, the Joint Secretary to the Ministry of Corporate Affairs, Government of India, and the way he took it forward, Dr. Saini himself, the Regional Director, Mr. Bhola, N.K. Bhola, his entire team, day and night they have worked to make sure that this becomes a reality. I have now been looking at Dr. M.S. Sahu, and we are very proudly saying as Dr. C.S. M.S. Sahu, who is, of course, you all know he is the chairman of the Insolvency and the Bankruptcy Board of India, and the way he is spearheading this regulator, it's commendable. When we look at the entire gamut of things, we now have to just figure out that where is it that we can give value addition to the country at large so that the society can be served. If you see the outline of the law, which we will also hear Mr. Dheer and Mr. Batra talking about it, we will find that it serves the larger purpose of the country. When we say that there are these various initiatives by the Government of India in the form of Make in India, in the form of Startup, Stand Up India, and to take the entrepreneurial spirit at its epitome, it's very, very important that the ecosystem in the country has to be so conducive that actual potential of our countrymen is absolutely achieved. We all know that India is a young population, India is a population who strives hard and knows how to excel, and therefore their entrepreneurial stint is the best in the world. Not only me saying that, but people across the world talks about Indians. So therefore, if that be the case, we all also understand that no business can be done just with that stint. You know, the money, the flush of funds is equally important, and therefore the government in the ease of doing business index, whatever we have been talking about, all of us understand that very well. But apart from that, it was also very important that the stuck resources in the economy has to be duly released, and probably the figures started saying more than was expected. We understood that the stuck potential in the economy was so huge and humongous that it was high time that through a proper law this could be unlocked into the economy so that it could become useful to everybody and anybody. That's the background by which this BLRC, that is known as the Banking Law Reform Committee, was formed, and it was also formed with an objective that each and every case that's doing rounds in different courts of law or in different forums should be consolidated under one platform, so that in the ease of doing business also people are not running from helter-skelter or not running from one pillar to the another, and their entire cases can be taken care under one platform. So I think it's a wonderful piece of legislation, very, very workable. The strict timelines are something which we always wanted. Sometimes when we are on the other side of the table, we always feel that, hey, this is too stringent. But when we are actually on the receiving end, we still feel that, hey, this is too long. This should have been probably less than whatever is mentioned in the code. So, you know, it's like seeing the glass half full or half empty is up to us. So let's welcome this code with open arms. As a professional, I could just say that this code has great opportunities for a professional, and when I say great opportunities, I truly mean that a person takes so much from the society, it learns so much from its course, from its experience, and you know, we long to showcase our talent. At times, we are able to showcase our talent in few verticals and not as a gamut. But seldom do we get a chance where we are able to really depict ourselves as a wholesome professional. And I think this code really gives us that opportunity where all our skill sets can be brought to the forefront, and we can not only serve our client, but through this we are serving the country at large. I assure you from ICSI that all the support that we can give through ICSI or through the IPA, there would be not a single stone which will be left unturned. ICSI IPA is also a Section 8 company. It's a wholly owned subsidiary of ICSI. So therefore, we are one and the same, but of course for legal reasons, it is two separate bodies. So let us not ever consider that, you know, we'll be at a distance. We are absolutely together. Having said that, I must also mention that a lot of emails are coming to me and also to other Central Council colleagues that why is the examination so important, and people are talking that Mamta, we are about 20 years of experience, 30 years of experience, and do you really think that with so much of grey hair and experience we still have to sit for an exam to qualify as an insolvency professional? I think with folded hands, first and foremost, let me commend the efforts of the Government of India. They have put everybody at the single platform. But having said that, they have said that people who are having experience, for them, you know, it's cracking the exams obviously is not a big deal. But what the government wants to mention is that let's get updated. When we sit for an exam, we start reading, we start updating ourselves, and maybe because the laws have become so dynamic, somewhere we may have lost some thread. We again come back to the groove, get connected, and just sit for an exam and get the requisite marks and get ourselves registered as an insolvency professional. At the outset, I also must say that from the first, on the 31st of December 2016, the first examinations were held, right Alkama?
Yes.
On the 31st December 2016, the first examinations was held by IBBI, that's the Board of India. And when a month back, when before that, you know, Mr. Batra, and you must be knowing, sir, Dhir Saab, that when we were talking about in the working group of IBBI, we were just wondering that will IBBI be able to put this examination structure so fast? And you know, at a blink of an eye, we saw that, hey, everything was out and the examination was out and all India people were ready to give examinations. On the 31st December 2016, clock struck 10 o'clock in the morning, the exams were held, and I think till today about 138 plus, a number here or there, 138 or 154 around people have appeared for examinations. I am giving you the figures till yesterday, and about 38 to 40 people have qualified. So therefore, people have started accepted. And there are two kinds of examinations which has started. One, in fact, just one which has started, that is limited insolvency professionals have to give examinations. Now, there are two categories, friends. A person who have 15 years of experience in practice. I am repeating, a person, a professional. Who is this professional to be defined? A chartered accountant, a company secretary, a cost accountant, or a lawyer. These people, if they have 15 years and above experience in practice, they can straight away register themselves. There was a date, there was a cut-off date. They could have registered themselves straight away under the category of limited insolvency professional. After getting themselves registered, within a period of 6 months, they have to appear for examinations and get the permanent registration with the Insolvency and Bankruptcy Board of India. Apart from that, a person who has 10 years of experience, not practice, it says 10 years of experience, would have to first give an exam, and only if they qualify in the exams, that is 60%, if they qualify for the exam, they would be eligible to apply themselves for registration with the IBBI. Now, this registration with IBBI has to go through an IPA. So, therefore, if a member who wants to register themselves as a professional with the Insolvency and the Bankruptcy Board of India would first have to come to the IPA. So, our appeal from ICSI would be that whosoever is viewing our webinar today, please do register yourself with the ICSI IPA for so many reasons which we have put it on the website, which we will be hosting it this week itself, and we would be more than honored to have you. I also take this opportunity to quickly acknowledge the hard work put in by the Institute of Company Secretaries of India through the Council of ICSI and the Secretariat of ICSI to have put this entire thing into place and make sure that we are in the forerunners of this profession. I also want to put on record the efforts put in by my Corporate Law and Governance Committee Chairman, Mr. Vineet K. Chaudhary, who led it from the front. I also acknowledge the presence of Shri Ashish Doshi, who is a Central Council member and represents the Western India Regional Council, who is also amongst us today. Thank you, Ashish Bhai, for being with us. And friends, towards the end, I'm trotting the world and people say that, hey, India has just got another law. It's so easy to enact and so easy to formulate, but so very difficult to make sure that these laws are functioning well in the country. And some people, optimistic and pessimistic, both kind of people we have, and some people who always sees the glass half empty would probably say this law is also not going to work. And then I always tell them this story that I get reminded that there was a person, you know, he was a father of a young child, a girl child, and very, very fond of his daughter. Not very rich, not because of the demonetization, but really was not very rich. But his daughter once said that, "Hey Dad, I want apples and I'm very fond of apples. Please buy me at least 2 of them." So the father took the child to the market, and he had 2 pennies in his pocket, and he said to the shopkeeper, to the vendor, that please give me 2 apples. So in 2 pennies he got 2 apples, and he handed over both of it to the girl child that he had. Immediately the girl, took the apples, one in the one hand and the other in the other hand. And the father was just about to tell her that, and actually he said that, "Why don't you give me one?" Immediately the daughter gave a bite to both the apples. Hurriedly she did that. So the father was so amazed and dismayed, and he was so sad, because he thought to himself that, "Look, I asked for an apple, and because she wanted to make sure that I don't take it from her, she gave a bite to both the apples." And just in about 1 or 2 minutes time, the daughter said loudly, "Hey Dad, please take this apple. This is juicier and this is also sweeter." Friends, we jump to conclusions very, very fast. I think this law, this code has to be given the due time so that it proves its worth to the economy and to all of us. The only appeal is that let us look at it with positive mindset, with positive eyes, and help the government of India to make sure that this becomes the finest code and it becomes an example setter for the entire world. Thank you very much. Without much ado rather, because we have our experts with us, it's very important to hear to them. I think ICSI has been very fortunate to have the best of the people from the country, and today Mr. Dheer and Mr. Batra, to whom we are grateful to you, sirs, that whenever we call you at a beck and call of ours, you're always available with your precious time, and ICSI really thank both of you for it. So friends, let's tighten our seat belts and make sure that any pearl of wisdom is not getting missed from our ears, and we hear to them with apt and rapt attention. So over to you, Mr. Dheer.
Thank you, Mamta, and thank you, Alka, for having us here, and thank you, ICSI IPA, for giving us this opportunity to participate in the first webinar that is being conducted with respect to the insolvency and bankruptcy laws of the country, and also to give us an opportunity to give our views and our opinions. And I hope participation from across will also come, and we'll all enrich ourselves with the discussions and viewpoints from both sides of the table. Now, what I would like to say is that we have been, as they say, as a country, marching into the new century and trying to take our place under the sun as one of the top economies in the world. We've been, over the last few years, being rated as the fastest growing economy in the world. However, we've been hobbled over the years by one very peculiar problem, and that is with respect to the insolvency and the bankruptcy laws in the country. Now, this relates back to a very ancient philosophy. We have the Hindu trilogy, so to speak, the Brahma, Vishnu, Mahesh trilogy, the creator, the preserver and the destroyer. Unless the cycle of life is completed, whether it is as an individual or it is in commercial and corporate existence, you create new companies, you preserve and grow new companies, and end of the day you have to liquidate new companies, because that is the cycle of growth. And unfortunately, we've had a very bad, historically we've had a very bad experience about dealing with liquidations and bankruptcies, and that is why the growth of the new companies, and it has affected not only growth of new companies, it has affected the growth of capital in the country, it has affected the pricing and the cost of capital in the country, which has actually hobbled the country for a long period of time. Not to say that efforts have not been taken. Over the years, in 1956, the country was still new, and we had the compromises, the arrangements under the 1956 Act, the scheme of arrangements and under the 56 Act, where many of these distresses and insolvencies and difficulties which corporate entities were facing were sought to be resolved. However, as we saw the decades passing by, and in the late 70s and early 80s, we realized that the distress now needs a specialized treatment, and it is not possible to cover it under the Companies Act itself. We got the SICA, the Sikh Industrial Companies Act in '85. Again, The performance of SICA left some things to be desired. It was not comprehensive and it lent itself to gross misuse. And the creditors movement, the movement towards empowering the creditors started. It is in 1993 that we got the DRT Act. In 2002 we got the SARFACI enactment, which is a foreclosure enactment, and then a very comprehensive revamp of the Companies Act was sought, and in 2013 we had the Companies Act. But even before the ink had dried, so to speak, on the 13 Companies Act, the thought process was that we still need a very comprehensive standalone legislation which takes into account every facet of corporate distress, bankruptcies, liquidations, so that we can move forward and, as they say, fulfill the will of Shiva. Through this philosophy and this experimentation and the historic perspective on these laws, we now have in our hands the Insolvency and Bankruptcy Code. This enactment, as very rightly pointed out, has been very quick in the making. However, the quickness has not been at the cost of great deal of understanding and in-depth analysis of what are the issues involved. The Bankruptcy Reform Committee's document was perhaps, and I think Sumant, you were party to it, and so were you, Mamta, has been one of the most comprehensive analysis of what is ailing the system and what is the mechanism to, so to speak, set the system right. The legislation which has emerged, in my mind, is a very futuristic legislation. Now, it is futuristic in the sense of how jurisprudence in this country has been in the past. In the past, we've had jurisprudence which has created laws which are very specific, which are very meticulous. Every aspect of the law is completely provided in the enactment, and therefore it has to be implemented. Insofar as the current enactment is concerned, keeping in mind the various issues which were sought to be cured, which is one of them was that this enactment deals with commercial decisions, and therefore the attempt was to take the commercial decisions as the primary mover of this particular issue or this area of jurisprudence or area of law, and also to empower creditors by giving them the creditor in possession regime as against the earlier regimes which were more or less debtors in possession regimes. With all this in hand, the enactment is very, if I may say, provides a very loose framework. It provides a framework, but it is loose. It is therefore flexible, and whatever detailing was required is sought to be covered in the rules and regulations, so that the changes and modifications can be made in double quick time, and we don't have to wait for legislative changes to keep modifying the legislation to fit in with the requirement of the times as the times may come. Now, the legislation actually changes the focus of dealing with this legislation in the judicial courts. So, from the judicial arena, the entire effort is to shift it into a commercial arena. In this commercial arena, it is the thrust and parry of the various stakeholders which will decide the delicate equilibrium which has to be achieved for the purpose of resolving and reviving companies. And if from commercial standpoint the stakeholders find that the company is not viable, then they don't have to go to judicial forums for passing any orders in this regard. It is they who are the arbiters of their own fate. They will decide that this company cannot be revived or this commercial transaction cannot be implemented further, and therefore take the transaction from a resolution framework into a liquidation framework. That's the broad aspect to it. There are going to be challenges, my friend, as been very rightly pointed out by Mamta. It's not for us to take a call on the enactment today and say whether it will work or not. If I may say so, I look at it from the perspective that it is the responsibility of the stakeholders, and indeed, in fact, if I may say, the citizens of this country, all of whom are very greatly affected by this enactment, to take the responsibility to make the enactment work. We have very little choices. We've spent decades, as I said, from mid-80s till now, almost 30 years trying to find the best fit for our country with respect to insolvency and bankruptcy laws. We have tried the debtor in possession regimes. We have now shifted into creditor in possession regimes. We have tried the judicial format. We've tried to see whether the judiciary can help resolve the issues, and now we have changed this to whether the stakeholders themselves can take decisions. What other choices are there? I mean, there is either debtors or creditors, either judicial forums or commercial forums. We've tried them all, and we've come to this particular phase in the enactments relating to insolvency and bankruptcy, where we have to try this experiment and we have to make sure that it is going to work. However, before I go into the CIRP issues and the processes which are framed under this enactment, what I'd like to say is that the entire enactment will require a very substantial change in the mindset of all stakeholders. The stakeholders in this particular area would be the creditors, debtors, workers, employees, state and central exchequer, etc. All of them have to understand and change their mindsets with respect to the commercial issues involved. It is not a question today of whether it is going to profit one particular individual more by behaving or participating in a certain manner, or for using the pulls and pressures of going through the judicial system, sometimes delaying the matters to get that extra edge in one's favor. All the stakeholders have to act with great maturity, and at the end of it, if they fail to act with maturity, it is they who are going to be the losers. If the company is not revived quickly, the value of the assets deteriorates, the money, which is the pie which is to be shared between the stakeholders, diminishes, and therefore everybody gets lesser and lesser. The whole business of insolvency and bankruptcy is to identify and share and participate in the loss which is there in the system. When a company is operating, I'm talking principally of corporate debtors and corporate entities. When a company is in operation, all the stakeholders have put their resources in the company for the operation of the company and for its successful working. Whenever there is financial distress, the first thing you have to identify and understand is now the value which is left in the company is lesser than what the stakeholders have put into it, and therefore there is a loss, and therefore a hierarchy has to be created for sharing the loss. Some will bear lesser loss, others will bear higher loss, and that depends upon the charges which they have and the manner in which they have put stakes in the company. Let us assume first charge holders, the creditors, are likely to get a higher share. Unsecured creditors are going to get a lower share. Workers need to be dealt with in a different manner because we are dealing now with human beings. They have been pushed into the pari passu structure for 2 years insofar as the workers are concerned and 1 year as the employees are concerned with the secured creditors. However, a very important factor of this enactment is that the government dues have actually been put far back down in the hierarchy of claimants, and therefore would be in all possibility obligated to bear a much larger loss. This whole system is required to work by creation of certain institutional framework. We are going to have insolvency professionals as the persons who are going to lead the process forward. We are going to have IUs, the information utilities, which will be the repository of the information which is required to make this work. We will have adjudicating authorities which will have as I say, would be some sort of an umpire in the process, because in the judicial, in the commercial arena, if I said so, when these stakeholders are playing there, the insolvency professional is in some sense the master of ceremonies, and the adjudicating authorities is some sort of an umpire, which is going to decide as to how all this is going to be participated. With this small background, let me come to the specifics, if I may say, of the CIRP process and how this will be done. Just a bit of information prior to before I start this process of how the CIRP works. Since 31st December, or if I may say since 1st of December, the CIRP process, possibly the filing of CIRP process has been possible by the promulgation of the rules and regulations relating to CIRP. Some CIRP applications have already been filed, and one of the first ones which was filed was in the NCLT Bombay, filed by ICICI in case of innovative industries. At 5:20 this evening, the decision on that application will be taken, because in the morning today the NCLT pronounced that they will be delivering the order at 5:20 this evening. So that would be perhaps the first of the orders coming out of the NCLT relating to a CIRP process. There is another application which is being heard in the NCLT Hyderabad today, and I think that was also heard in the morning, and then 2:30 in the afternoon today the hearing was to be conducted. So a decision on that is also likely to happen today. And I am aware of another matter which is coming up in Bombay NCLT tomorrow morning, and I have the privilege of appearing in the matter tomorrow. So after finishing this, I would be going ahead and seeing what can be done. And any of these three can perhaps be the first admission in the country, and it will actually kickstart the CIRP process in real earnest, rather than being just rules, regulations and provisions of law in the book that we have. It will actually be in the practical framework of how they are going to be implemented. And I must say, I wish best of luck to the enactment and all the stakeholders in this enactment, because all of us need to take advantage and benefit of this enactment. Having said all this, I would just express to you how the CIRP process is to start. One of the important issues at the stage of starting the CIRP process is that rather than the erosion of net worth, which many, as was there in the Sikh Industrial Companies Act, and a lot of flack was there that it is the starting of the process at a very late stage, and at a stage, if I may say, where the revival of the companies was almost non-existent because they had gone so far down the path with respect to the distress, that there has been a complete change, and the IBC now talks in terms of default as being the starting point for referring a case to CIRP. Now the default can be the first default, and indeed very importantly, it can be default with respect to any kind of creditor, whether it is a financial creditor or for that matter it's an operational creditor, and also the corporate applicant, which is the distressed company itself or its management or its CFO who has been dealing with the financial affairs of the company, who are entitled to file this application. So friends, it is the first default, and in fact it actually changes the perspectives very, very significantly. The intent is that at the very first stage, when you see that there is a default which is happening, you are entitled to come to the NCLT for facilitation through the CIRP process of revival of the company. So the company is at a stage where quick steps can be and quick remedial measures can be taken with the consent of all the parties for the purpose of revival of this company, rather than waiting for long and it going down the path to such a degree that it becomes irredeemable. On the filing of an application, if I may say, so as I mentioned that either the financial creditor under section 7, operational creditor under section 9, or a corporate applicant under section 10 can file this application. Importantly, it is only the operational creditor who is required to give a 10 days notice before filing of such an application. Insofar as a financial creditor or a corporate debtor is concerned, there is no timeline, there is no requirement of any prior notice to any defaulting borrower or to anybody for that matter before this is filed. On the filing of this application, a timeline of 14 days has been provided for the purpose of admission of the application or for rejection of the application. Primarily, what is required by the NCLT, which is the adjudicating authority to see, is the factum of default. That is the only real issue that has to be seen. That has to be proved through either information available with the information utilities or in the current rules and regulations, since the information utilities are not in existence as on date, on the basis of material data which is loan document, legal notices, default notices, CIBIL, ROC filing, the MCA filing, all these or any other information which is relevant, which can demonstrate or prove a default, is all that is required to be placed. By the 14th day, I wouldn't say on the 14th day, we'll all hope that these timelines can be compressed. The adjudicating authority, the NCLT in this case, has to decide on the admission, if I said. And if they are admitting the application, the proposed insolvency professional, because when an application for filing under CIRP is there, the applicant has to propose an insolvency professional. So on the date of admission, the NCLT would appoint the proposed insolvency professional as an interim insolvency professional, as an IIP. This IIP is required to hold office for a maximum period of 30 days. We will come to what will happen and how this process will run, but importantly he is going to hold office for 30 days. On the date of admission, the PIP will be appointed as the IIP, that is one. The second is the NCLT will cause for the public announcement to be made. Now, this public announcement has to be made within 3 days of the admission of the CIRP application. Within 3 days, the public announcement will be made. What is required in the public announcement is to specify that this company has been admitted to a CIRP process. It is also inviting claims from all the creditors with respect to the specific corporate debtor. The date on which the admission is made is also a very, very important date insofar as the timelines of this CIRP process are concerned, because that would be treated as the insolvency commencement date. It is from that date of admission that the period of 180 days which is prescribed under this enactment will run, and it is during this 180 days that the entire process of revival and resolution of the asset will be conducted and carried out. This 180 days is sacrosanct, and at the same time there is a flexibility which is given within the enactment that if 75% of the creditors agree, then this period of 180 days can be enhanced to by another 90 days to 270 days. But that's the timeline, friends. Within 180 days or 270 days, if the process can be completed, the company would be revived, and if the process cannot be completed, it is a straight journey into liquidation, and the liquidation provisions of this enactment will take place. Now, having appointed an IIP, having issued a public announcement with respect to this particular company, another step that has to be taken by the NCLT is that within 14 days of the insolvency commencement date, the order with respect to moratorium under section 14 of this enactment will be passed. Now, this moratorium is a standstill clause, and routinely across the world, wherever the provisions with respect to resolution of bankruptcies are there, such a standstill clause is there, so that nobody is able to come and disturb the operations of the company during this period, and the company gets a breather time to enable it to revive and resolve itself. However, insofar as the moratorium, if you compare it to what was the moratorium provided under section 22(1) of the SICA is concerned, there are some very distinct differentials. The routine issue of all suits, etc. are already there. They were there in the past, they continue to be there. But arbitration has also been now, arbitration has also now been covered under the moratorium clause. That's a very important aspect. The second important issue is that the SARFACI provisions, section 13(4), and for the purpose of takeover assets and sale of the assets under the SARFACI Act have also been covered under the moratorium. So, once the moratorium kicks in, the SARFACI for that period of 180 days or 270 days as the case may be stands suspended. So, these are very important aspects. Then comes the appointment of a registered valuer to calculate the liquidation value. This has to be done under regulations 27 within 7 days of the appointment of an IIP. Now, this is also an extremely important process and a step. It has great relevance to the entire process of rehabilitation and revival of the company, or for that matter when it goes into liquidation. What is warranted is that the IIP will appoint 2 valuers, and the valuers are mandated with the requirement of determining the insolvency value of the estate, of the assets of the corporate debtor. This number, this figure which will emerge will be an eye-opener, if I may say, or a lodestone, however you look at it, with respect to all the stakeholders. They will have to understand that this is about all that there is in the kitty and no more. As we are all aware, the banks and financial institutions sometimes, because of loans they have given, because of provisioning requirements that they have certain predetermined numbers in their mind. They don't want to do one-time settlements, they don't want to do restructurings with respect to the borrowers, because they perceive the value of the loan on the basis of what they have given, what is the interest, etc. which has accrued in it, minus perhaps the provisioning that has been done. But that number, friends, has no relevance to reality. Yeah. That's a number which is in thin air. Merely because there is a number, there is an amount that you have to recover from a borrower, it does not mean that there is any mechanism or there is any substance or there is any asset base which will lead you to that number. The banks are very chary of recognizing the loss. Obviously, it directly affects their balance sheet on that date, and therefore they tend to, if I may say, brush the valuation of the assets under the carpet and try to see if they can resolve and get the value to protect their own balance sheet.
Yeah.
That impact is very important. So this, as I said, is a lodestone and an eye-opener for all the stakeholders. They have to now realize that we are sitting on the table with this much pie, and rather than having their own thoughts about what values they can get from this, they should concentrate that how are we going to share this pie and what is the mechanism that we should utilize to ensure that this doesn't deteriorate any further, and therefore the focus has to shift from their balance sheet impact to the question of what is the economic value of the assets that they can derive. And therefore, as I said, it's very important. There are other details that if two valuations are different from each other substantially, a third valuer can be appointed, and an average of the two values is to be taken, but those are matters of detail. The basic concept is to have this, if I may say, number on the table so that everybody sits and understands what kind of value they have to share. The next step, as I said, is once the public announcement has been made, within 14 days of the appointment of IIP, it's not 14 days from the public announcement because 3 days have been taken away for the public announcement. It is 14 days from the appointment of an IIP that the claims have to be filed. So we have actually really only 11 days within which the claims have to be filed by the creditors.
Also, at times they feel that these are working days, or these are days which you start reckoning from the day the event kicks off, or that day should be left, the last day should be left. So there is a lot of confusions. So we have probably, what my understanding is that there is no working day concept, because like in SEBI, if it is working day, then it is actually explicitly mentioned as working days.
Absolutely.
So what is your opinion?
I would say that there is a certain bit of grey area here for sure. The working days, there is no concept of working days. It has not so been defined.
Yeah.
The 180 days in any case are not working days. 180 days are 180 calendar days.
Absolutely.
Obviously, under the General Clauses Act, if a date falls on a date which is a holiday, if an obligation is to perform something and it falls on a holiday, it falls on the very next day, which principle is bound to apply. You can't have something to be done on otherwise a holiday.
Yeah.
Having said that, I would like to point out that this is an issue which has been concerning all of us, that these timelines have been established. Up to the 180 days, all kind of timelines are established, and I have read some of them, and I will come and mention some others to you. But there is nothing which is given as a consequence for violation of the timeline. Now, let us take for this instance the first 14 days. There is a requirement of the NCLT to pass an order with respect to admission of a CIRP in 14 days. If they don't pass an order, then what? Is the 14-day period over? Are they barred from passing an order?
True.
There is no implication. If they pass an order after 30 days, still the CIRP will be there, and still the 180 days period will start after the end of that 14 days, because the 180 days kicks in only once the admission order comes. Similarly, now there is a 3-day period, as I said, for public announcement. If it is not given in 3 days, it's not given in 3 days. No heavens are falling.
No, but let's not.
Only thing is, no, what I'm saying is we have to look at it from the perspective that they're certainly not working days. The compliance with these days is something which I would say, which is a responsibility for each stakeholder, and I would say that even the adjudicating authorities in this process are stakeholders. They are responsible for working and ensuring that this enactment
for the limited purpose of understanding of this webinar, probably, just I'm going a little off track, but this is important because we get questions, almost many of them. The 14th day will also begin from the day we lodged that petition or application?
Absolutely.
Or should it be counted or reckoned from the next day? So, we may take it in the question answer session.
Actually, again, if you really ask me, the day of filing should be excluded. Day of filing should be excluded. But these are matters which will be finally decided by courts of law. And you're quite right in saying to maintain the timeline and the focus. I mean, we can, of course, these are such nuances of law that each by themselves will require a webinar to clear.
And also, if I may interject at this stage, just to make a couple of observations. There's also some confusion about as to the 7 days that have to be given to the debtor to make corrections if there are defects in the application, whether they have to be inclusive of 14 days or have to be in addition to 7 days. So therefore, if it has to be added in addition to 7 days, then it becomes 14 plus 7 days, isn't it? And the other thing which Alok was mentioning, there is a very unique provision in the law which says that in the event the tribunal wishes to extend the time at any stage or for any stage, for example 14 days, they have to actually take the approval of the president in the case of the NCLT and the chairman in the case of the NCLAT if they need to extend the time. Now, and that time also can be only extended up to 10 days, right? But it still leaves open as to what happens if it is not observed. The other point that I wanted to make was that as far as the resolution professional is concerned, because he's like, for example, expected to issue the public announcement in 3 days, appoint the valuers in 3 days, there, although there may not be any penal consequences as such, but there is a loss of reputation.
Yeah, very
right?
true. Yeah.
So if the professional is not following, then he is not meeting the expectations of the creditors or otherwise. So he may not be punished by law, but in terms of his reputational loss, it will impact his future appointments to some extent. And that is how I think the incentives in the law will work.
Thank you.
Thank
Yes,
you,
sir, please.
thank you both of you actually for throwing more light onto this. But let me come back to the, as they say, tread the narrow path with respect to the CIRP. So I was at the stage when the claims are required to be given, and I pointed out that it's not 14 days really. Effectively, it's only 11 days because 3 days have to be taken away. But very interestingly, the creditors are required to file the claims within 14 days is one issue. However, if the creditors fail to file the claims within this period of 14 days, they have time up to the date of finalization of the resolution plan for filing what they say claims at any point of time. So the 14 days period is relevant only for the purpose that once the claim has been received by the insolvency professional, the IIP at this stage, within 7 days he has to verify the claim. And on verification of the claim, it is the IIP who will establish the creditors committee. So if somebody fails to give his claim, if a financial creditor fails to give his claim within the 14-day period, the disadvantage for him is that his claim is not verified. He doesn't therefore have a seat, so to speak, on the creditor committee, and therefore the question of 75% of the decision making empowerment which is there in the creditor committee fails to include him. So it's a very substantial issue for a creditor, and I'm sure all creditors will be very mindful of the implications of such a dereliction, if I may say so, of in filing their claims, and they would in all probability file their claims within this period of time. Now another the next date, relevant date which is important, is the 30th day from the date of the appointment of an IIP, which incidentally is the as I said, insolvency commencement date. It is on this date that the IIP has to submit a report to the NCLT with respect to the details of the claims, the verification of the claims, the constitution of the creditors committee, and it is a very important timeline. He has up to 30 days to do this, because this is what actually steps, if I may say, in motion, it puts in motion the process of the creditors coming on board, because till this date it is the insolvency professional who has been appointed as a proposed insolvency professional by an applicant, which could for that matter as well be the corporate debtor himself or any other corporate applicant. It is the first time that the details of the creditors committee emerge as to who is going to lead the entire process henceforth. The creditors committee meeting has to be held within 7 days of the submission of this report. And if one would say, there is a slight grey area here again, because his tenure is up to 30 days, so 44th day his tenure is over. He has to send a report within 30 days, so 44th day is the date on which he has to send the report. The meeting has to be called within 7 days, so there is a 7-day period when he is not there. He is not in existence. The law also requires that is an insolvency professional who will be chairperson of the creditor committee. So there is a bit of a grey area. One doesn't know whether it has to be therefore completed within 44 days, which means there is only 37 days. Or if he completes it on 44th day, how the meeting will be conducted. But be that as it may, I mean, I'm sure law will be made to iron out such creases. But it is on, I'm taking it as 44 plus 7, the 51 days. It is on this date that the first creditor committee meeting will be held, and this is a very important meeting, because it is the main reason for this meeting is for the creditors to decide whether they would like to continue with the interim insolvency professional as the resolution professional, or they would like to replace the person. It is quite possible that there is a creditor, there is a corporate debtor application, and when the creditors step in, they may like to replace it and have a person who they feel will be more having, if I may say, more responsible to their sensitivities and their claims. Though any insolvency professional, whether it's an interim, whether appointed by an operational creditor, corporate debtor, or anybody, has a fiduciary responsibility to the creditors. Therefore, in all probability, that should not be an issue, but in any case, this is an opportunity, first off, for the creditors to decide whether they want to take it into their own hands by appointing somebody who's directly, if I may say, proposed by them rather than by somebody else. Then the next stage after this is within 14 days of the first creditor committee meeting, the insolvency professional, if I may call him a resolution professional now, because he has changed himself from being an interim resolution professional to a resolution professional. It is within 14 days from the first meeting of the creditors committee that a information memorandum has to be prepared and placed on record by the insolvency professional. The information memorandum is again a very important step. It in the process, it contains the information with respect to the company, and it is in the nature of an invitation for any person to come forward with a resolution plan. The scope of the CIRP is that when a company is under recovery and resolution, it is open to any party concerned who may have interest in the asset, whether it is a creditor or it is a corporate debtor himself, or even a third party who may be interested in this particular company and is interested in reviving the company, to come forward and give a resolution plan. It is the information memorandum which actually provides it with the data and information which is required for the purpose of, if I may say, generating a resolution plan for the takeover of the company. The next stage now is the period of time where any resolution plan is being proposed, any party is considering giving a resolution plan. So it is for the first time now the timeline has shifted from the date of the insolvency commencement date to the date on which the 180 days when it is supposed to finish. The next timeline, if I may say so, is 30 days prior to the completion of the 180 days, which means the 150th day. So the time has, we are now reverse calculating the time. It is by this point of time that a resolution plan has to be submitted by the insolvency, the resolution professional before the NCLT. The purpose is that there should be a period available to the adjudicating authority, the NCLT, to consider whether this plan is appropriate or not, and whether for the purpose of sanction of the plan. Now, insofar as what this plan may contain, what kind of plan can come, Regulation 37 of the CIRP regulations deals with this. They talk in terms of transfer of all or part of the assets of the corporate debtor to one or more persons. This means sale of part or full undertaking, as you found under section 18(2) of the SICA. The sale of part of all or part of the assets subject to security interest or not. Now, this is very important, that there could be certain assets which are not charged. No security interest is created on the assets, what one would call free and unencumbered assets of the company. So, the part or sale of such assets can also be provided under the resolution plan. The substantial acquisition of the shares of the corporate debtor, merger or consolidation of the corporate debtor with another company. So, this takes into account two principal aspects. One is the takeover of the company by taking over the shares of the company. The second can be by merger or consolidation of the corporate debtor who is under the CRP process with any other entity. So, merger, amalgamation and takeover get covered. One important issue that is arising here is whether the SEBI exemption for the takeover code with respect to listed companies will be provided or not. As of today, the SEBI has not come up with this exemption, with any such exemption. In the past, the cases of High Court, where schemes of merger and amalgamation were to be decided, there was an exemption, and so also with respect to cases covered under the SICA. The plan may also provide for reduction of dues to the creditors. So if the creditors are there, certain claims are there, they could provide for reduction. Also the extension of maturity date and the interest rates, which means that if the debt has to be paid within a timeline, the period for repayment can be extended. There is no specified timeline as to what is the period that should be provided for extension. It could be, as you are aware, under the SARFACI Act, schemes are being prepared by ARCs running into 5 years to 8 years. It could be any such period. It could have periods with respect to certain amount of debt being put in as a zero rate debenture and being put in the 14th year or whatever. So timelines are completely free and flexible. Anything that passes muster, if all the creditors sit together, if this is something that is acceptable to them, will be followed. Now that is the kind of resolution plan that will be placed before the NCLT. NCLT is now required to look at the resolution plan and to approve it. Now there are 2 or 3 very peculiar issues with respect to the resolution plan which I would like to say. Primarily, if the plan is acceptable to all creditors and the plan is such that it is not violative of any law of the land, the NCLT will approve it. That's one aspect of it. But 2 very important issues are there. One with respect to the operational creditors, which I would like to point out. With respect to operational creditors, the amount of money which was available to the operational creditors, if the company was to be liquidated, is the minimum amount which is required to be provided for payment under such a resolution plan. And this payment is required to be made within 30 days of the approval of the resolution plan in priority to all financial creditors. Therefore, the operational creditors have been given this special treatment. They don't sit on the creditors committee. The creditors committee is constituted only of the financial creditors. And therefore, they are in the sense of persons who have provided goods or services. They are not lenders. In that sense, their staying capacity, if I may say, is not long. They are not people who have lent financial monies and therefore have long terms and can give long duration timelines to the corporate debtor for payment of their dues. They have provided services or they have provided goods, and they need to be paid instantly because their own businesses could suffer otherwise. And therefore, the minimum amount of liquidation value is required to be provided to them prior to payments being made to the financial creditor. The other aspect, which also in some sense is being debated very vehemently at this stage, is with respect to the dissenting financial creditors. Now, the regulation 38 provides that if there is a dissenting financial creditor, that means a financial creditor who is sitting in the meeting and is constituted of the 25% of the dissenting, because 75% of the creditors can make any scheme go through. If he is the part which is dissenting, the minority part which is dissenting, if he dissents, then the amount which will be paid to him through the liquidation route, however money he is entitled to be paid through the liquidation route, will have to be paid to him upfront. This will have to be paid before any money is paid to any financial creditor who is approving the scheme. Some say that this actually puts the assenting financial creditors into a disadvantage and gives an unfair advantage to a dissenting financial creditor. The idea being that there is a advantage to be dissenting. If you decide not to participate, you will get paid before all other people who are agreeing to the participation of the scheme. However, there are other views involved. First is that he will be given the money which he is entitled to under liquidation. There is a very old adage. The value of an operating asset is far greater than the value in liquidation. So if you are going for a process of taking a larger chunk of money based on the operating and cash generating capacity of a company over a longer period of time, it is possible that you may be able to take more than the value which you would be entitled to if the company is forcefully liquidated under the liquidation process. So there is every possibility that a dissenting financial creditor may actually get a lower sum of money than his peers, than his other financial creditors. However, he will get the money faster. So it's a call that each of the creditors will have to take with great deal of maturity. So I would say with this sanction of the rehabilitation plan, the CIRP process goes through. If there is no plan presented within the period of 180 days by the resolution professional, or for that matter a plan which has been presented has failed, or the creditors at any point of time during this period of 180 days with a majority of 75% resolve, that the company should not be taken through the resolution process but should be taken into the liquidation process, the company will by law be forced into liquidation. There is no other, as one would say, subjective issue to be considered by the adjudicating authority for taking a company into liquidation. These are clear-cut, well-defined steps. If these do not happen, or if they happen in a way that I have just specified, the company will go into liquidation. Just to close this in the next few minutes, I would say that there are certainly certain challenges in the CIRP process, and these are to be kept very much in mind, just so that we have a comprehensive understanding of the process. One is the strict timelines. Mamta has alluded to them. We've all had some discussion about what are these timelines and what are the consequences of the timeline. The reality is that some of them are a bit tight. I mean, let me just say, the creation of an information memorandum, the 14-day period is woefully small. We've all been part of the due diligence processes. As lawyers, we've done mergers, takeovers, amalgamations. We find that due diligence itself takes long. I, in my own experience, have hardly been able to do a transaction of takeover or merger or amalgamation without the process taking about 6 to 9 months itself. In due diligences, in terms of drafting definitive agreements, etc. So to have an information memorandum and expect that somebody will come and give a bid on the basis of this information memorandum without appropriate and complete due diligence is, if I may say, little too much to be expected. However, in case of pre-packs, where prior to the filing of the CIRP application, a lot of hard work has been done by the corporate debtor and the other stakeholders, and it is not unusual. In fact, around the world, the filing of the CIRP, the zero date, if I may say so, in fact happens not necessarily at the state of default, because it is certainly, that's the stage that you can come in, but after a lot of work has been done, the borrowers often take the creditors into confidence, and there is a lot of effort which is done to derive and work out if there is any arrangement which is possible for reviving of the company, including by way of takeover, merger or amalgamation, and therefore the process starts only after that. So in some sense, I would like to reflect upon this as being one of the timelines. There also some level of flexibility was inevitable and ought to have been provided to the adjudicating authority for extensions of time. It may be that transaction is very, very close to its closure, but the gulleton falls. I mean, 180 days or 270 days is like a gulleton, and it could be actually a great deal of disservice to the company because the issues are not, the company could not be revived just on account of that timeline rather than anything. Then I said liquidation is inevitable. Further loss of value on liquidation is inherent. The mindset, as I said, of all the stakeholders is exceedingly important, not to repeat it, but all the stakeholders have to act with very great maturity. It's not just the secured creditors or unsecured creditors for that matter who have to take a decision with respect to the erosion of their value and a realistic understanding of what money they can make. But equally, the pragmatic decision is for the corporate debtor to take, and the promoters of the company, they have to take. They have to also understand that the decisions have to be taken in their own self-interest. Sometimes they have personal guarantees which have been given, which have to actually be also taken up with the NCLT. The judicial involvement is very, very important. Judiciary has to have a great deal of forbearance. They have to see that this particular enactment has to work on estimates, has to work on general commercial interest rather than very specific judicial pronouncements, and therefore they have to give a far greater deal of flexibility and openness for the process to prosper and carry on to its natural conclusion. And the information utilities, the creation of the information utilities is an exceedingly important step. Unless they are created and participate in the process may be rudderless, if I may say so. Lastly, I would like to say, if only bankruptcies were so simple. The reality of the matter is that we are in a very, very complex environment. It is not a simple environment. It is not just something which you can run down on a timetable and say this is what is expected to happen. A company is a living organism. It takes its own time to revive itself. Common colds get cured in 7 days, whether you take medicine or not.
Very true.
Insolvencies don't get cured in 180 days, whether you want it or not. Thank you very much.
Thank you, Mr.
you.
Dheer. That was really, you summed it well and you said it well, and I'm sure after hearing Mr. Batra, we'll actually go back home today highly enriched. I know we are talking of insolvency and bankruptcy, and just on the other side I'm talking of enrichment. But you have to believe me, because after Dr. Batra speaks about it, we will also try and put this on the YouTube so that it will have a higher shelf life, and any time that you would like to view this insolvency seminar through webinar process, you can actually go and look at it. Without wasting any more time, because we'll have our closing remarks from the side of ICSI also, wherein we would like to throw some light as to what we expect from you as a professional. Let's hear Mr. Batra.
Thank you so much, Mamta, as well as Alka, ICSI, IPA, and ICSI as well for offering me this opportunity. I want to focus more on the conceptual aspect. I want to focus more on the philosophical aspect. I want to focus more on the inherent principles rather than just the letter of the law, because I'm sure you all are very capable of reading it and understanding it as you go along. But before I actually get into the nuances of the role that would be expected to be played of you, I just want to make 3 key observations. Now, first of all, well, I think this law has the potential to be a game changer for 2 particular disciplines. One is the company secretaries and the chartered accountants. This really is, in my opinion, a groundbreaking opportunity for you, and it is up to you how you come forward to take it. This is not as much for lawyers, let me tell you. I mean, because we are based in a UK model where the administrators are largely appointed out of chartered accountants, and because in India the company secretaries have an important management role, the government has also included them as being eligible for appointment or qualified for taking licenses. Then of course eligibility depends on a lot of other factors. Now it is entirely up to you as to how you make use of this opportunity. The other observation that I wanted to make was that there is one thing which should be absolutely clear in the minds of all those who assume any kind of role in the insolvency process, whether they are the consumers of the law or those that are operating on the periphery or perhaps sit at the heart of it, that it is an economic law. The entire approach to this is fundamentally different from what you may apply to the corporate law, barring of course the fiduciary duties, that perhaps there is an overlap in terms of how the fiduciary duties happen and how the investigation that have to be held into it. But other than that, the principles that have to be applied, the tools and techniques are going to be entirely different. So there is a lot of unlearning that you have to do alongside the learning. Absolutely. That is what needs to be understood. And the baggage of the past will have to be dropped, and new, whole building blocks will have to come together. And that only will help you in applying that fresh approach that is needed to make insolvency law work. And I'll of course talk about that a little bit when I deal with some of the specific issues. The third observation that I wanted to make was that understanding only of the insolvency law is not going to help. The insolvency law has an entire solar system of its own. There are a number of related laws that operate in the orbit around the insolvency law. You need to understand the secured transactions law. You need to understand how securities are created. You need to so how they are perfected. You need to understand how charges are created, how priorities are determined. You need to understand the collateral registries that you would need to interact or interface with. You need to know the industrial and labor laws, because as we all know that you will be taking over the management if you're appointed, and therefore you need to understand the laws that are applied when you run a business. You also need to understand, of course, the corporate law, which is of course the simplest for you, I'm sure. But there are other laws as well, and these could be also, of course, like FEMA, because there might be external commercial borrowings involved. There may be other kind of regulations depending on which constituency the enterprise operates in. So these are dimensions that you need to keep in mind, that an understanding of the insolvency alone may not be sufficient, and therefore you need to have a greater understanding of the periphery and the surroundings of the insolvency law, with which you will have to interact from day one. From the word go, you will need to have that understanding. You will not have the time. I'm not saying that you need to have it all perfect, because you will need to rely on, and you will surely rely on, a large number of advisors who would help you in that process, which you would be able to and entitled to appoint. But the fact is that unless you have basic, minimum, elementary understanding of all that, you would not be able to take a considered decision, because the risk will be yours. Howsoever many advisors that you may appoint, the risk would be entirely yours, and therefore you need to be fully mindful of all the laws that apply and the compliances that will have to be done. And I think that's what's going to be the key to the success and the speed of the resolution process, because if you don't understand that, every moment will be a moment of hesitation, and that would take the stream out, and if you take the stream out of the whole process, it's not going to go out. So that will only work if from the day one, from the moment one, you're all ready to go out. It is in this background I want to understand with you, because for us also it's all a process of understanding as to how is it going to work. Obviously there are duties, there are powers that are mentioned in the law, but what is it that really makes the basis of all these powers and duties? There are two principles, there are two expectations, there are two driving factors, there are two primary rules of the game, if I may say, which is all what forms the basis, or from which stem out all the powers, expectations, duties, obligations. And I just want to focus on those primarily, because once you understand those, you will know, what all it means. The first is the obligation of the resolution professional is, and I'm talking about both at the interim and the resolution professional who's confirmed, is to keep the corporate debtor as a going concern. That is one of the two guidelines, the principal guidelines, which will determine your liabilities, obligations, efficiency, your fee. Everything will be determined on the basis of how you act on these two principles. To be able to keep the corporate debtor as a going concern, so that the process of resolution is not defeated from the day one, or the value doesn't go down. And the second is to protect and preserve the value of the assets. Now these are all duties which go beyond being fiduciary duties only. These are specific duties which will be tested at every step, because if there is a valuation report which is available prior to and within 3 days when a valuer is appointed, there will be a certain amount of valuation of the enterprise which will be available to the world. And if 60 days down the line that valuation is going down, a part of the responsibility for that will have to be shared by the resolution professional, because he is the one who is now taking all the decisions on behalf of the enterprise, and then he'll find it very difficult to shift the blame on anybody else. So therefore these are the two principles which I believe we will have to, the mantras that we will have to live by, each of those 180 days or the extended days if the days case be. I mean, I would say that these should be really written in bold letters on your desk, because these have to be reminded to you every moment of your decision making, every spirit of your decision making, every rationale of your decision making, and every target of your decision making will have to be based on these two principles, whether I'm achieving both of them, if not one out of them. This is what has to guide us. It is in this regard that all the powers and duties have to be performed, now, which are all out there, and I don't want to sort of in a textbook format go through that, because I'm sure you can all read them. But I just want to sort of tell you from a more more responsible way as to how it's going to work, and from that point of view, I have divided into 3 categories of duties, I mean, or 3 stages of duties. One will have to take in the first 24 hours, and the other which you will have to take soon thereafter, and the third you will have to do on an ongoing basis, which would include from the first 24 hours itself. Now, as from a practical point of view, as soon as you receive an order of appointment, or if you've been warned by the creditors or the debtor that your name has been proposed, and of course you will have to give a consent, you will have to start mulling, thinking as to how is it that I'm going to achieve these 2 purposes that I just spoke about. And while you do that, of course, as Alok mentioned in his presentation, you will need to do 2-3 things in the first 2-3 days, which is, of course, take out the public announcement and appoint the valuers, which is the simplest part, of course, because that is an obligation which is given to you by the law. So therefore, you will look at the statute and say, oh, this is what is required of me. But the biggest challenge, and that is what I keep coming back to these 2 issues, is you have to look at the law to see what is it that is not mentioned in it, but is expected of me. Because that is where the real success of the outcome of your services will lie. And as I mentioned, like for example, there is no provision in the law which makes it obligatory to have a communication strategy, right? There is no provision which says that you will start communicating with A or B or C and how you would communicate. But the entire efficiency, success and outcome of the approach that you apply to the process will depend on what communication strategy you form in the first 24 hours. How should I start speaking with the creditors? How should I reach to those parties with which I have ongoing contracts, with my suppliers, with my workmen? How do I call the CEO in the first place and explain to him, this is what it is, I need your cooperation, go and speak to the workmen. Then go to the workmen and speak to them. Go and speak to the regulator, meet the regulator and explain to them. So there has to be a very definite, well considered strategy. And in bigger cases, you probably would also need the help of a PR firm, because you will need to hold press conferences, because you can't reach out to every communication person, every stakeholder yourself in case of public companies, or in case of even other enterprises which have large consumer or otherwise. People start speculating in the market. There are rumors that go out. You will need to dispel those rumors, because those rumors have the effect of taking the value down. So if there is a bad press happening, it is affecting your valuation, right? If there are major contracts being cancelled or withdrawn, or suppliers who have shut down, who have decided, that means that your valuation is coming down, which of course will also mean that your ability to sort of make the concern as a going concern is going to also impact. And therefore, a very, very important area would be in the first 24 hours, put together a team and say, okay, this is the communication strategy that I need to take, and roll it as soon as possible. And that, of course, in that process, one would need to sort of appoint on an immediate basis a certain set of advisors. Depending on what skills you think you are capable of managing on your own or delivering on your own, you will need to appoint a certain set of people. And the first one will have to be a lawyer. That's the first thing that has to go out of your email box, which is to ask a quote from a certain set of law firms or lawyers who have experience in these areas, who can immediately advise you of the next steps, and also on an ongoing basis. The second, of course, as I mentioned, that you may need a PR firm depending on what it is, and you also, of course, may need, besides the valuer, who in any case is something you will be obliged to appoint, you may need otherwise. And in UK, for example, if it is or even in anywhere in the world, and that would be true for India as well, you may need a sector-specific expert to immediately come in and assist you. If supposedly it's an airline sector, I mean, you may not be an expert on airlines, so therefore you would need to immediately look for someone who's worked as a management consultant and immediately hire him to give you some consultancy on that in terms of what decisions need to be taken, because you won't understand the licenses, you won't understand the number. Of course, there are people who within the organization will be available, but you will also need to have some degree of outside advice, because you will have to have a degree of suspicion on the internally. Even I'm not saying that one must, but it's a caution that you will need to apply till such time that you have a comfort that I am being fed credible, right information, I am being guided rightly by the management. Even if you are appointed by the management on the recommendation of the management itself, you would still need to have a certain degree of independent assessment to the information, so that your responsibility at the end of the day is based on both inside and outside advice. Well, obviously this team has to be put together on a very cost effective basis, because it's also as I mentioned, that overburdening the whole resolution process with excessive cost is also not healthy, and the creditors will always be reluctant to part with good money to go after the bad money. And therefore, I think one of the things that one will have to sort of also immediately think in future is, although of course in this case whosoever moves the application has been given the responsibility to spend money on the public announcement. That part has been taken care of because that's an immediate requirement. But you'll have to pay for the fees of the valuers. There are other aspects which will have to be addressed, and it may not be, because the creditors committee may not have been constituted immediately. So therefore, how and where will you get that support from? The debtor company may not have enough in its kitty to be able to meet that cost, and you may also need that money for paying the essential bills and others.
And in any case, it has to be approved by the creditor committee.
Yes, that's right. And eventually it will have to be approved by it. Now, obviously, therefore, you will follow certain best practices that operate in the market, which are also meeting the expectations of the creditors. In UK, for that matter, and I think this is something which we as an industry will have to start developing very soon, is there is a concept of litigation funding, which is very popular. Now, there are third parties, litigation funders, who come in and supply this money to be able to for the resolution professional to spend on pursuing litigations or defending litigations, and of course they have a prior claim on that. Although in the law this cost has not been addressed as a part of those that will be receivable, but in UK now, and even in Australia, these are now considered by virtue of court orders as administration costs.
I must say the law does provide for it. The insolvency professional or the resolution professional can raise this money, provided 75% of the creditors agree.
So, for example, I am talking of the, like, say, the interim corporate resolution, who will not have the assistance of the creditors. And in the 30 days is a long time to, if supposedly somebody is filing a suit, taking injunction or shutting down the business or whatever, or a contract is being rescinded. So somebody will have to take action. So this is something which we will have to develop as a practice on in times to come. But at this point in time, I just want to flag this issue that we will have to find very innovative ways to discover the money to be spent on litigation. Because without that, if there are attachments happening, if there are 50 litigations happening, the valuation is going down. Your energy is being spent on managing those or arranging money for those rather than paying attention to the business, which has to go on. The other biggest thing that you'll have to think of in the first 24 hours is how to take control of the management and the assets. That's going to be one of the most tricky parts, because it's not symbolic possession that you need to take. You don't have, somebody just doesn't have to sign, because that happens by virtue of a fiction of law, because the law gives you that power in terms of assuming that role. You don't need a specific order from the management. But the fact is that you will still need to go and sit in the CEO's office. So you will need to find a place to sit in the organization. You can't be really sitting out of only your office and doing it. That may not work. You will have to do the factory visits. Somebody will need to provide you access. Somebody will need to take you on a tour. Somebody will need to explain to you. Somebody will need to come and show you ledgers of supplies, what the asset list is, how credible that list is. And we all know the real practice has been that even though you have taken possessions and SARFAESI or otherwise, within 48 hours or less than that, assets sometimes are taken out. Right? Now, the fact is that in those cases, the banks, everybody remains silent. Nobody really determines the accountability. But in this case, immediately somebody will come after you. If these were the assets which were there, if they've gone, it's your responsibility. So you have to take steps to make sure that these assets remain protected. And which means, of course, appointing your own security agency, but all that's not going to happen in 24 hours or in 48 hours. But the fact is that the first week, be assured, will be spent doing all this. 24 hours out of the office, and not just you, there will be a team of 20-25 people doing that, and I've been part of many such teams and exercises, and this will not be necessarily limited to one city. You know, you may be actually then taking control of 5 assets located in 5 different cities or even abroad. So all that will have to be, strategy and actions will have to be done in the first 24 hours, because 24 hours is a long time. If the news goes out, which will be within 3 days when the public announcement is made, if a creditor based outside India gets apprehensive, he will start initiating something there. So you'll have to immediately probably appoint a lawyer there to make sure that, you know, they start talking to the creditor to make sure they don't initiate a parallel proceeding there, or stop the line of credit or whatever. Now these are the kind of things that you need to be strategized in the first 24 hours.
Looks like a kidney transplantation or a heart surgery, both
It is,
of it.
but the best part is that, you know, I'm sure like people like Dr. Trehan do 50 surgeries in a day. You start enjoying it at some point in time, because it's so challenging, and then you look for challenging things.
True.
Because first 15 days, if it's the vanilla cases, you're saying, yaar, maja nahi aa raha hai because I need something more challenging now, right? Then you raise the bar, and also you raise the fee, because depending on how best you are performing,
Absolutely.
will you be paid, and that's why the government has left the resolution process fee part untouched,
Yes,
because they want the market to determine it, because they want incentives to come forward to the resolution, to the practitioners. Pay well, serve well is going to be the mantra.
Yeah.
And therefore, you know, we need to be...
In the working group, the government was discussing with this, and the government took a lead and said, no, let it be market driven totally.
Yeah, that's right. Although in liquidation you will have a criteria, which is of
Yeah.
course provided in the law itself to a large extent
So
as a
there's question on
guideline.
this only,
Yeah.
that who will pay the fee to the IP?
Yeah, so
And how
which he
much?
said
Who will
actually.
decide how
You see,
much? Who will pay?
obviously it has to be paid out of the assets
Out of the
eventually,
assets,
but initially creditors have
Creditors
to,
committee.
to have to pay.
Yeah.
Now whether they pay it or
Creditors
not,
committee will decide,
yeah.
no, how
so
much.
if there are creditors who are difficult and who are not cooperative, then you will have to find ways. You'll have to go to the court and say, okay, fine, I'm borrowing, I'm signing a contract with this insurance companies. I mean, in UK there are established models on this, very well regarded. The only thing which they have recently started discouraging is because in UK, insolvency practitioners themselves started funding it.
Yeah.
They said, okay, the law firms would say, okay, fine, or the accountancy firms would say, okay, fine, we will.
Yeah, we don't have a contingency practice here in India, because if you see class action suits, that in UK, US, people, if you win the case, you are, you know, you are able to say that I'll take 1% or 2%.
But now this has
Here
been
in
sanctified by
India-
UK and Australia courts also. They have said that this will be treated as an administration cost. If it's a cost of administration, then it will be recovered as your fee, or
Yeah,
as an
that
cost
is
of
also
administration.
being treated here in India, in the
See, it's not
insolvency.
contingency. What happens is, because in this case there is only so much money, and the fees is not based on contingency.
Right.
But typically, what they do is, if a law firm charges, let us say $500 per hour,
Hmm.
they will bill you for $750.
Absolutely.
So that will take care of the risk that they are
Yeah.
taking in giving you legal services at this stage,
Yeah.
without this money being
Absolutely.
provided.
Okay.
Yeah, so I would say then after the first 24 or 48 hours, then your attention moves to the compliances, because then you would start calling the legal advisor of the company and the company secretary and the chartered accountant, and start asking what compliances need to be done, whether any licenses that need to be renewed on an ongoing basis, what compliances have been done before the registrar, whether food licenses are there or not, depending on which industry you are in, whether the telecom license fee has been paid or not, if there is an installment due, how do you pay? Now you have to start paying attention to that aspect, compliance part of the operations, because there are other people who are doing the operations in which ways. Not that you will, I'm saying that all this attention is to the exclusion of the other areas, but in terms of the prioritization, one has to focus on these areas, because these have a direct bearing on not just the valuation and the going concern, but on your liabilities, because this will come back to haunt you. So therefore, that's why, in my opinion, this is how you have to prioritize as a checklist. As that this is what I need to do immediately, so that tomorrow nobody questions why you have not done this. Then I would say that there would be assets which you will find difficult to recover. They may be on the books but not in physical possession. So there is an obligation in the law to recover those assets, and therefore we will have to go after that, and that will also have to be a strategy which may involve litigation, but may even involve persuasion. So you may have to have a strategy of persuasion, and you will have to get into people to say, okay, fine, you know, I'll negotiate with you, give me this asset, and allow me to sell it, or let it come as a part of the estate of the enterprise, and I will try to find a pie for you. Those are the kind of skills that need to be applied, because you will not have to follow a kind of a bookish approach to this. That's not going to work. You will have to step into the role of CEO in one moment, role of CFO in another, CRO in another, and then an independent person as a resolution professional. These shifting of the roles have to take place every second is what will need to be done, and which is what one is going to get paid for. I mean, it's not a social service that is expected to be done by a resolution professional. We are entitled to demand a full fee for this, depending on the kind of work that it will involve and the skill also. Of course, the risk also has to be factored in. I think since in first the appointment of the interim resolution professional is for 30 days, which also involves setting up the creditors committee, inviting claims, all that exercise will happen on the side. But there will also have to be what we may call as an alert all the time, sniffing and smelling that will have to be done by the resolution professional. The sniffing and smelling is to make sure of two things: to investigate what the real reasons of sickness are. What is it that really brought the company to this stage? Which means he'll have to travel back in time. Besides, of course, talking to people, you will have to look at the actions that have taken place in the preceding period, a period from where one would be able to assess that this is the time when probably any normal person would have been able to assess that the company is getting into the distress strategy, which is typically called as a twilight period in the insolvency parlance. So you will have to travel back in twilight zone to see, one, what are the reasons for sickness, because without addressing that you will not be able to have a resolution plan. Second, also to investigate if you come across any suspicious transaction, whether it's for the purpose of avoidance, whether it is for the purposes of any other area where the fiduciary duty was not satisfied.
Or extortionate payments.
Or extortionate payments were done, or all those kind of things, decisions taken, which probably are not error of judgments, but intentional business decisions taken to cause this affair, or to perpetuate it, or to maybe not contain it. Now these are what will have to be done, because these are linked to a separate set of fiduciary duties that come out of the insolvency process, which are in addition to those that exist in the Companies Act, for which there are separate sets of punishments that are provided in the law, and it is an obligation of the resolution professional to bring them to the notice of the regulator so that they can take suitable action. But also that will decide the basis also for the creditors to be able to decide whether they have an ongoing confidence in the current management or not, and to be able to make an independent decision. Now for this you may not have that expertise, so you will need to bring in forensic experts. But of course that is only if you have a certain sense of suspicion, which you are able to say, and therefore you feel that it requires to be investigated. So immediately bring in forensic experts to do an audit and come out with an interim report, and based on that he can take a decision whether a detailed investigation is required, whether he needs to do it himself, or whether he should defer to the regulator, because he may not have the know-how, bandwidth, or the resources to be able to do this. But this is something which will be an obligation. It's not just a duty, because if somebody else point it out, then the market will see it as a failure of your duty to have done that, and ideally this is something which you should have done. I'm not talking about the settlement of claims and everything, which is very clear that you have to invite these claims by way of the public notice, deal with them, and also present it as a part of the report when you send it to the NCLT, when you also send the report of the constitution of the committee of creditors. Now there are other aspects which I also want to mention, which may also happen within these 30 days or even later on, which is to raise interim finance, which is going to be one of the most challenging tasks in order to make sure that the company goes on doing business. One may require finance on an ongoing basis, and the current creditors may be reluctant, and the law enables the resolution professional to be able to do that. Now the resolution professional, the interim resolution professional can raise interim finance without going to the creditors committee for approval, as long as he is not encumbering any assets which are already charged, or if the value of the assets which is charging is double. I think it's double of
2x.
Is 2x of the assets of the value that is already charged to the other creditors. Now in the case of resolution professional, obviously he'll have to take the committee's approval to be able to charge any assets. But the fact is that it is highly, it's very, very difficult to be able to persuade a third party to come in as long as the creditors are not cooperative or are willing to cede charge. Unless, of course, the SSM are far greater in value, which is going to be very unlikely the case, even at least in terms of the creditors agreeing to the value. Even if the value is high, the creditors will always say it is not, and therefore they will make it very difficult. Usually, therefore, the players that operate in the market, which of course India also, they have a foot in the door to a large extent, is the distressed asset funds. And I'm glad that even the regulator and government of India is also looking at that market, because without that, it's going to be very, very challenging to be able to raise not only interim finance, but also to be able to find real players in the information memorandum, interested in the information memorandum. So that's going to be one of the key issues. I have already spoken about the management of the list, but a couple of more points that I want to mention very, very quickly, and then I'm going to finish, is the confidentiality of the information. Because the fact is that you are the custodian of huge amount of confidential information, which may really be the real strength of that enterprise. I mean, for example, God forbid if somebody gets appointed as a resolution professional of a Coca-Cola company, the very formula.
Yeah, absolutely right.
Yeah? So those are the kind of things that you need to have complete confidentiality, because the liability should be the intellectual property as well. The time management is going to be, of course, we've already discussed that. That's going to be one of the biggest challenge.
And the art of even minutizing and taking on the decisions, because that's going to be the future.
Compliance is absolutely
That's right.
essential. That's the only safety
The art
valve
of jotting down
for
the
a
decisions.
resolution process.
And that's why, you will find that legal lawyers also constantly will be advising on every single thing, because you will need to equip yourself with that from all point of view, but the responsibility will be yours, because lawyers always give their advice with disclaimers, and so therefore you will have to have sufficient grasp of the law and how it works in practice, so that you are self-dependent to that extent. At the end of the day, you are going to be a lonely person, because when you actually are going to be knocking the door of the NCLT at any point in time, you will always be knocking a lonely person. So therefore, it's always good to have a handbag with you which contains all the documents, but only those documents which you would be expected in the normal course of business to take out of the company, but not that you're carrying every confidential documents, everything with you and things like that. Now, these are the best practices that we'll have to all collectively develop. People like you who have great experience in the field of management of companies, advising companies, compliances with those as accountants and lawyers, we all will have to come together and formulate best practices. So all of us will benefit from this. But I would say that in spite of all the challenges, in spite of all the temptations, the fact is that this is a great opportunity. This is something which is not to be missed. And the education exam is just one small thing. The education process has to be an ongoing basis. You will have to be much more on the toes as they're going to be. You will always have to be ahead of them in terms of imparting and sharing with them the knowledge of the market, the best practices, how they're developing, and making sure that they never feel that you are one step behind them.
Absolutely.
And constantly develop on the best practices. So I'm sorry I made it a bit rushed, but
No, that was very, very appropriate.
Thank you.
Thank you, Mr. Batra. I think we've got few questions, and let's do that round, and then we'll try and do a wrap-up session.
Yeah, there are a lot of questions, but we'll take some of the very important ones here because of the paucity of time.
And something which has been covered is not required.
Yeah, I'm not going to read those. So one is, can an entity recognized as insolvency professional entity be appointed as an insolvency professional? This many people are asking this, many of our professionals.
The answer is quite clear, and it's not possible.
Not possible.
Only individuals will be appointed. I think the IPE is for the purpose of putting that ecosystem around an insolvency professional and a team which they have. Call it an O&M team, or call it a team which will help them conduct, if I may say, conduct the process. As he said, valuers, advisors, and there's a lot of crunch work to be done. If claims have to be verified in 7 days, you have to have a whole team of people to do that. So that's what the IPE will facilitate.
So friends, it's very clear that the IPE entity cannot be appointed as an insolvency professional. It is the individual who gets appointed as an insolvency professional. So what is an IPE? What Mr. Dheer said is absolutely right. But the liabilities, I think, the
Yes,
liabilities has to be, the liabilities and obligations has to be shared
Yeah.
by all the members of IPE.
Yeah.
In case of fraud, I think not otherwise. In case of fraudulent activities, etc. Friends, we have to be very careful. This entire law, if it is used for malafide intentions, the law can really take a bad route for the insolvency professionals also. So let's not ever fall into a trap where this route, this code is being used malafide for different varied reasons like pressure tactics, etc. Though if it is used viably, absolutely fine. But wherever you find that it's being used malafide, just do not put your hands into it. That's a humble appeal from ICSI also. Yeah, what's the second question?
Yeah. When a CIRP application is initiated by a financial creditor, how do the other financial creditors join him? There cannot be multiple applications against the same corporate debtor.
See, I think
it is through the committee of creditors.
No, I think it's the Wild West, if I may say so. And it's internationally, this is what happens is the person who's first at the draw gets at least his interim insolvency professional in place, insolvency resolution professional in place. Thereafter, the creditors committee will decide whether to retain that person or to change that or replace that person. So in that sense, sometimes it works best to have the first toe in the door and get your own person who you believe is more competent to handle the resolution process to be there at the helm, at least at the initial stage. As I said, it's a very, very important part, the first part.
Although I do believe that yes, if supposedly a corporate debtor files an application and they recommend their own resolution professional, I do believe that the creditors, if they have very serious difficulties, against that person, they can always approach the NCLT, and we'll see how the process happens thereafter. Although, of course, on the vanilla reading of the law, it seems that only after 30 days that he can be confirmed or removed.
Friends, so anyways, we'll compile all the Q&A and we'll make it a point that within a period of 7 days, we mail this Q&A and we also put it on the website.
Yeah.
Yeah, what's the next question, Alka?
The cases which got abated from BIFR, whether fresh applications are required to be filed with the NCLT irrespective of the stage where they were.
Yes, actually
Yes.
BIFR, friends, BIFR and BIFAR is no more in existence. So about 90, the figures say that about 93,000 odd cases were pending. So now that is no more in vogue. So all those cases have to be, obviously will be going to NCLT. A fresh application needs to be made. Number two, if that application, that fresh application is being made within 180 days of the closure of BIFR and the BIFAR, it need not be accompanied with an application fee. But beyond that, if you are making the fresh application beyond 180 days, it has to be accompanied with an application fee. So the limited answer to this question is that yes, a fresh application needs to be made within 180 days, no fee, beyond 180 days with a fee. Yes, ma'am. What's the next question?
Yeah, the other one you've already covered. What is the time period
That's
within
done.
which we
Forget
should
it.
now
Yeah.
initiate?
So
So it's
next.
already done.
Yeah.
Then insolvency professional fee we have already covered. Whether appointment of IP is mandatory for voluntary winding up.
No, voluntary
These
winding
rules
up
are
still
still under-
remains.
yeah.
Voluntary winding up still remains under the Companies Act.
But it is mandatory.
So, yeah, it is
I mean,
mandatory.
the regulations, we had the working group
Absolutely.
5 meeting,
Absolutely.
today, working group 3 meeting today.
Right.
The regulations are being discussed.
Being
but
discussed.
in law, the liquidation, voluntary liquidation can only be carried out by a resolution professional.
Yes,
Yeah.
but as of today, it's not
The
still
rules
active.
are not yet.
Not been
Yeah,
notified.
so it's
yet.
under the Companies Act, wherein you do not need to appoint an insolvency professional. If you talk on as on today.
I am an
Right, of course.
advocate and a company secretary working as a software engineer for the last 12 years. Am I entitled to be recognized as an IP?
Yes, your experience of, you will fall under the category where you have to give a examination. First, you have to give an examination, pass the examination and then become an insolvency professional. Because in that category of 10 years, they talk about experience, they don't talk about an experience as a practitioner. So in that category, you are absolutely eligible. But I just want to put a disclaimer here that if you ever take up an activity as an insolvency professional or a profession of being an insolvency professional, you cannot still continue to be in employment. So you'll have to make one choice whenever, you can get yourself registered as an insolvency professional, but the moment you take up any activity or any assignment, you cannot continue in employment. Yes, next.
All others are procedural, which
Okay.
we've already
Friends,
covered.
I would actually, we are just about 5 minutes away from closing this program. 2-3 more points, which is running rounds of lot of confusions in the country. Let me tell you, this insolvency professional agency, any institute that has brought up this agency, as on today, we have 3 insolvency professional agencies in the country. One is floated by the Institute of Company Secretaries of India, the second one by the Institute of Chartered Accountants of India, and the third one is by the Institute of Cost Accountants of India. In any IPA, I repeat, in any IPA, any professional can get themselves registered. Now, as an example, if you are a chartered accountant and you want to get yourself registered under the ICSI IPA, not under, the right word would be with. If you are a chartered accountant and you want to get registered with the ICSI IPA, no one stops anyone to do so. So, for example, if a company secretary wants to get himself registered with the IPA floated by the Institute of Cost Accountants of India, there is no stoppage to do so. So, therefore, you are completely free as to choose which IPA to get yourself registered with. Second, IPA is not the regulator in the real sense. The regulator is the IBBI, that is the Insolvency and the Bankruptcy Board of India. We as an IPA would be in fact regulated by the IBBI. So, the basic feature of a IPA, that is of an Insolvency Professionals Agency, is of course to discipline the people who would be registered, getting themselves registered as insolvency professionals, and number 2 would be to train and educate and enhance this profession of insolvency professionals. Third point that I want to really mention is it opens a floodgate of opportunities. Very well said by both our esteemed speakers. But please be wary of the fact that number 1, we are experts. Okay, the definition of expert will still be borrowed from the Companies Act. If you see the structure of the Insolvency Code, any definition which may not be specifically mentioned in the code can be borrowed from the Companies Act. So, as an expert, we all professionals are expert. So, we would be definitely be exposed to provisions like fraud, to provisions like misfiancé and the mismanagement and sort. So, we will have to be very, very careful while we are discharging our liabilities and responsibilities as an insolvency professional. Number 3, let us not get swayed by too many assignments coming to our door, because you know the floodgates are opening, 93,000 cases in the entire country, very limited number of insolvency professionals. In the limited category, I think IBBI has registered about 947 insolvency professionals. Yeah, either 974 or 947, whatever. Less, just close to 1,000 insolvency professionals. So, the work is galore, we are few, but we have to be very, very careful to pick up the right amount of work that we will be able to take it up. So, that was one more point. And fourthly, I think this needs a lot of study. You know, it's high time that we start becoming students, and let us shed that idea of knowing everything and not wanting to read again, because it's quite a nuanced law and it will really need a deep, deep study. I also want to put on record that the exams are becoming tougher day by day. Yesterday, I was just having a talk with a regulator, that is the IBBI, and one esteemed person there said, "Hey Mamta, you should also pass the examinations now." I said, "Yes, I'll relinquish the office of the president, and the first thing that I'll do is I'll start preparing for the examinations." And he very seriously said that we are adding 500 questions every week in the question bank, and we are obviously raising the level and the bar of the questions. So, therefore, it's in your interest and it's everybody's interest that they should come forward and pass the examinations sooner and not later. So, not on the lighter side, really on a very serious note, I would appeal to all of you that let's get going, let's study hard and crack the examinations. From the side of ICSI, IPA and ICSI, we endeavor to bring the best to you. Look at those sessions all around, but then the Sale of Goods Act, Contract Act, you know, all these acts that the module has it, we have read all of them in our textbooks. If not anything else, we can borrow the textbooks from the final and the intermediate pass students of ICSI and start flipping over the pages and learn it well. Friends, I know time is running, and just about in 1 minute's time we would close, and I want to say that Government of India wouldn't have probably brought this law at a much opportune time. I went to Dubai about a month back, and I learned that even Dubai has very recently got an insolvency and the bankruptcy law. It has become effective from the 1st of January 2017. Now, look at the size of the economy of Dubai, or the population of Dubai, vis-a-vis what we, I'm not comparing with Australia, New Zealand, UK, US. They're all matured economies, and they've had this law about so many years back. But if we see with Dubai and ourselves, Dubai got the law very quickly, you know, they hardly, I think they have just conversed with it for a year and they have brought it. I think India is India has actually done it so well, because this code has learned from all the mistakes that has happened in other parts of the world. It has picked up the best piece of legislation or the best sections from around the world, and now this code is a mixture of the best from around the world. So this is actually well poised and very sure to work. Whatever our esteemed people have mentioned from the dais is definitely going to be there in every law or every legislation that comes by. We live in a very, very dynamic kind of an environment, situation. So whatever holds right today may not hold right tomorrow. But I'm sure this is a visionary code, and let's get going without too much indulgence into what's going to happen. Oh, that's too difficult. Let's just get going with a plan in mind, as Dr. Batra said, and I assure you that it will be fun for all of us to work in this. I think it's a treat for any professional to work in insolvency code, because it really gives a platform and a field to work in every little sector or every big sector that you really wanted to. From ICSI and also from ICSI IPA and from the entire council of ICSI, we wish you all the very best, all success, and don't only bring laurels to yourself as a professional, but give us some part of that laurels so that we can take ICSI to newer heights. Thank you very much, and thanks for being there with us.
Thank you.
Jai Hind.